DeWaal here, and this is Bridging the Week for March 9th to 13th, and today is March 16th, 2015. Good morning. The 40th Annual FIA Boca Raton International Futures Industry Conference ended last Friday, but many of the topics discussed during the event will resonate for months. These included the profitability of futures commission merchants, capital, clearinghouse risk, and what is the appropriate amount of clearinghouse capital that should be made available to the default waterfall, and new initiatives involving back-office outsourcing, Bitcoin, and China. Meanwhile, another lawsuit involving spoofing was filed, but this time not by a regulator and not against a specifically named defendant. We have some very interesting topics to cover this week, so let's get started. In an address before the FIA Boca Conference, Timothy Massad, chairman of the Commodity Futures Trading Commission, suggested that long-standing issues that have so far resulted in European regulators not recognizing United States clearinghouses as subject to equivalent oversight may be close to resolution. Without such a determination, European banks utilizing U.S. clearinghouses will potentially be subject to a penalty capital charge beginning June 15th. In his presentation, Chairman Massad also provided some insight into how the Commission views the debate about the appropriate level of clearinghouse skin in the game without revealing the likely outcome of the CFTC's deliberation. In general, the Chairman suggested that a determination of an appropriate level of clearinghouse skin in the game should be viewed in the context of what is an appropriate alignment of incentives between the clearinghouse and its clearing members. This is particularly relevant, he said, where the equity of clearinghouses is typically now held by outside investors, not members. HTG Capital Partners filed a lawsuit in a federal court in Chicago against unnamed defendants, claiming they engaged in spoofing and manipulation of U.S. Treasury futures contracts traded on the Chicago Board of Trade on quote-unquote thousands of instances during 2013 and 2014. According to HTG's complaint, which formally named John Doe's as defendants, the firm seeks through discovery to identify the precise persons responsible for the alleged wrongful conduct. Once learning these identities, the firm proposes to amend its lawsuit to name them specifically. HTG claims that defendants' wrongful conduct comprised three phases: placing orders on one side of the market they intended to cancel before execution for the purpose of inducing other orders by third parties on the same side of the market, canceling their orders, and virtually simultaneously with their cancellations, placing orders on the opposite side of the market to trade against the orders they initially induced third parties to place, conduct sometimes referred to as flipping. In response to the September 2014 decision of the United States Federal Court generally rejecting challenges to the cross-border guidance and interpretations issued by the Commodity Futures Trading Commission in July 2013, the Commission last week issued an initial response and request for comments. The CFTC's guidance had sought to explain how the agency would apply the provisions of the Dodd-Frank Wall Street Reform and Consumer Protection Act related to swaps and its recently implemented swap rules in the cross-border context. Although the federal court mostly upheld the guidance, it ordered the CFTC to conduct a cost-benefit analysis in connection with the extraterritorial application of many of its rules addressed in the guidance. In response, the CFTC issued its initial response, noting, quote, it considered costs and benefits on the understanding that the swaps market functions internationally with many transactions taking place across international boundaries, end of quote. Comments to various questions raised by the CFTC are due by May 11th. Stephen Bell, the senior compliance officer of two firms that engaged in advisory activity regarding pension investments, mortgages, and general insurance protection products, was sanctioned by the UK Financial Conduct Authority for the firm's failure to have adequate compliance systems and controls related to the retention, training, and supervision of registered representatives. Mr. Bell was sanctioned despite FCA acknowledging that, quote, Mr. Bell took significant steps during the relevant period to introduce and improve the firm's compliance systems and controls, end of quote. However, these measures, quote, were ultimately insufficient to ensure that the firms complied with the regulatory requirements and the, quote, claimed FCA. The two firms, Financial Limited and Investments Limited, are part of the Standard Financial Group. In resolving this matter, Mr. Bell agreed to pay a fine of 33,800 Great British pounds, or approximately 50,000 US dollars, and not to serve as a senior compliance officer for any firm in connection with activity regulated by FCA. To me, the sanctioning of a compliance officer regarding the alleged inadequacy of a firm's procedures, absent some affirmative misconduct, appears dangerously to transform compliance officers from advisors to a firm to potential guarantors of the firm's compliance with all applicable laws and regulations. This is too great a burden and fails to distinguish the difference between an advisor and a supervisor, even accepting that compliance officers have proactive obligations and cannot just give advice and then turn aside and blindly ignore unlawful actions when they know or reasonably should have known they are being committed. And finally, 5 federal and New York State regulators sanctioned Commerzbank AG for violating various federal and state laws aimed to ensure compliance with the United States sanctions against specified countries and individuals and other anti-money laundering requirements. Among other things, the regulators charged that from at least 2002 to 2007, certain business lines within Commerzbank developed and followed procedures that deleted or caused certain information not to be included that permitted the processing of U.S. dollar-denominated fund transfers through its New York branch or unaffiliated U.S. financial institutions without an assessment of whether the transactions complied with applicable regulations of the Office of Foreign Assets Controls of the United States Department of Treasury. Also, the bank was charged with failing to adequately oversee its New York branch to ensure its compliance with applicable AML and Bank Secrecy Act requirements, to provide timely and accurate information to regulators regarding transactions of foreign customers through the New York branch, and with inhibiting efforts of personnel in the New York branch to strengthen transaction monitoring. Among other sanctions, Commerzbank agreed to pay aggregate penalties of 1.71 billion US dollars to implement a program to ensure its compliance with applicable Bank Secrecy Act and AML requirements, and to terminate 4 employees, quote, who played central roles in the improper conduct, end of quote, among other sanctions. The 5 regulators involved in this action are the Board of Governors of the Federal Reserve System, the U.S. Department of Justice, the District Attorney for the County of New York, OFAC, and the New York State Department of Financial Services. Well, that's it for this week's edition of Bridging the Week. As always, there is more information in each article and more articles on the article version of Bridging the Week on the Bridging the Week website. Check it out. Until next week, this is Gary DeWaal. Have a great week and ciao!